their case. My Lord, in the normal course of things, and this is a bench, one of the 50th or 70th bench that we are hearing before, the first business of the court before the directions of hearings are given, which we thought we could do on Friday, has always been what is the estimations of the advocates of the time that is necessary for them to do fair representation within the meaning of Article 50 of the Constitutions. My Lord, we are here, we know the urgency of the matter, but as petitioners, on that issues of time allocations, the petitioners wants to plead and beseech the court that each of the application by the petitioners, we shall need 1 hour each to carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record.
I'm sorry to interject. Start with your 20 minutes. If they are not enough, we will consider. We're here. We shouldn't worry about time.
My Lord, for purposes of that issue, if I could just finish. The problem that we have, because we need to organize ourselves, that the time that has been given, one is going to do this and the other. Why that is absolutely important is that at this particular stage, because this has been a recurring thing, that there is instructions to be carried out. This is a court of record. We would want a fair allocation of time from the inception so that we are able to feel that at the end of the day, we did not refer to the court as a substandard case or an incomplete case. So it is only the minimum fairness that we should have.
May I say something on the issue of time before the court gives directions?
Let time not be the issue here. Advocate Ongaya, please sit down. Let time not be the issue here. Time can be availed. We can be here the whole of this day. We can be here the whole of this day. So let time not be the issue of discomfort. We will give you the time you want.
Thank you. Thank you so much, my Lord. That's an impressive direction.
My Lord, Your Ladyship, the sole purpose of conservatory orders under Article 23 of the Constitution, which gives this court power to issue conservatory orders, is to preserve the substratum, the subject matter of the petition. Here, for purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumes added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist in his place. Our opponents will be pointing out to you where it is that undermining the president is one of the grounds. My lords, the people of Kenya, in retaining sovereignty in themselves, elected leaders, members of parliament, senators, deputy president, the president, to serve them. They are the employers. The deputy president, the members of parliament are employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords, your leadership, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague, Elisha Ongoya.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ongoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of those submissions. When we retire, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled petitioners' submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my lady. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my lady, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions my lords will remember the words of the late Justice Chunlal Magwanda's Madan in that famous case of Githunguri versus Republic, where he urged Githunguri to run unto the hills, face east, and thank his gods that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this case. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive judiciary. I have one question for you, my lords, my ladies. Will you drop the ball or will you hold the ball to the finish line? By way of paraphrasing is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, our country has become fit our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find whatever the scope of interpretations. Number 3, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, to the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October to 17th October, when a resolution was taken by the Senate, had pretenses, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit. Now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears and a fundamental scholar, my good people. No Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our constitution. We are now left with only one institution, this judiciary. I don't know where that noise is from within here. I think if they are doing renovations, they may be told that this is so important a day for renovations. We may defer them to another day. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I will not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the president himself. The president of the Republic of Kenya undertook these clearances overnight and in the morning had a clear proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office, and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerogoya. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Ogola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief, because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of Clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look far. You will see why you must confirm these conservatory orders. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I would invite you, when you retire, to look at the ruling of your brother, Justice Mwita, of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I would invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme the judge addresses by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you'll see a lot of paragraphs 1, 2, 3, then it ends, and we begin paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following things at paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said to have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Chacha Mwita holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c. Then he reproduces the provisions of the article verbatim I wouldn't want to regurgitate that because you'll read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or a deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the clincher. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Gachagua'S has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Gachagua'S of 15th October 2024, in petition number 550, page 9, you'll find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, he says, I'll read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that it is important to let the impeachment process run its course, after which the court would have a look at any complaints on violation of either the Constitution, the law, or fundamental rights, including processes. After which the court would have a look at any complaints. He's again asserting the jurisdiction of this court at this stage. Then, I would also invite you to look at at page 10 of that same ruling. At that same ruling. And this is the clearest warning that Justice Gachagua'S was sending to the National Executive and the National Legislative Institutions Parliament. At paragraph 9 on page 10, he observes, in other words, constitutional processes are not about dashing to the finishing line, which is what they were doing. It's not about that. They were being told what you are doing is child's play. And we are not here about child's play. We are here about the Constitution. He says there is an allegation that fundamental imperatives in the Constitution have not been complied with, which is the allegation that you have before you and complied with the Constitution or the law. As it goes to court, I began by saying we need not look further than in the files before you to assert that these orders have been confirmed, and I'm beginning by confronting the unfortunate allegation of lack of jurisdiction that has been filed on behalf of the person who was nominated to be the deputy president and who is supposed to uphold the Constitution. At paragraph 10, he gives the most enduring philosophical statement of page 10, paragraph 10, page 10. In that respect, our Constitution offers both hope and promise. Hope that the institutions it has established will comply with its fundamental principles. We now know that that was hope against hope. And promise that the Constitution is supreme, and any act or omission in contravention of the Constitution, I want to speak the truth here. In the face of these pre-existing rulings in these files, you will hear arguments here of non-justiciability of this dispute, political question doctrines, things that have been fished in a cut and paste manner from old American jurisprudence into a transformative constitution of the 21st century. I mean, that's unfortunate. I am hoping that once I'm done with this, those who came to court carrying those arguments of political question doctrine, non-justiciability, will find favor in abandoning them to save us some time. Another paragraph 1. I tell you, the judge was starting paragraph 1 at every new issue. Not only the hope, but also the promise of our Constitution that we must abide by constitutional dictates, for any act or omission in contravention of this Constitution is invalid. That's what the judge is telling us. When you look at the files before you, my lords, you'll also find the ruling of your brother, Justice L.N. Mugambi, in petition number 522 of 2024, His Excellency Rigathi Gachagua versus the Speaker of the National Assembly and others. Another file that is before you. At page 9 of that ruling, you will find paragraph number 34. In that paragraph, the judge observes, and that was when he was delivering the ruling to send this file to the Chief Justice to empanel the three of you to sit. He says, Article 165, Clause 3, Paragraph B or D of the Constitution has been delineated by Article 165, Clause 4 as constituting areas from which substantial questions of law might arise to require composition of a bench. He then goes ahead and reproduces Article 165, Clause 3, B and D. He's saying, before he sends this file to the Chief Justice to empanel a bench, he must satisfy himself that the dispute in question falls within Article 165, Clause 3, Paragraph B or D. And he made the determination that the dispute falls within Paragraph 165, Clause 3, Article 165, Clause 3, Paragraph B and D, and send the file to the Chief Justice to empanel the three of you. The three of you are sitting on this bench on a finding that the court has jurisdiction. In the absence of that, the dispute would have been outside the ambit of Article 165(4) for empaneling of a bench. Then there is your own jurisprudence as this bench. "13 days ago, on 16th of October, 2024. 13 days ago, the three of you, my Lord Justice Ogola, my Lord Justice Mrima, my Lady Justice Frida Mugambi, delivered yourselves on this question of jurisdiction. In that ruling, in petition number 522, as consolidated now with the others, in that ruling that you delivered on 16th of October, at paragraph 83, you observed that at the moment, that was at that time, this court is being called upon to anticipate the outcome of a process yet to be completed. The application at this point is premature and anticipatory. In any event, should the petitioners not succeed before the Senate, they still have an opportunity to approach the courts. The applicants cannot therefore say they have no remedy. Now, I was asking myself as I prepared, I'm imagining you now telling us, no, you have no jurisdiction. Having told us this, my lord, how will you look at each other? How will you look at us? You told us yourselves, go to Senate. Once you have finished, come here. Then we come here and you agree with my friend, Dr. Mudomi Thiankolu, these are political questions and therefore we cannot deal with them. These matters are unjusticiable. How basic decency militates against at least the three of you, saying you have no jurisdiction. I respectfully submit, my lords, my lady. You observe that paragraph 85, that this court, and I was asking myself, what does the word this court mean? This court means two things. You said, this court has unfettered jurisdiction to check the constitutionality of the process at whatever stage. As such, we are certain that the petitioner's rights are currently well guarded and none of the petitioners stands to suffer any prejudice. You assured us that you have unfettered jurisdiction, that's what we used, jurisdiction to check the process at whatever stage. I've said the word this court, I understood it to mean two things. One, to mean the High Court, because you are talking about this court. I don't think you had forgotten you are judges of the High Court. So that when somebody comes and says, we ought to have gone to the Supreme Court, they must also justify to you why you are using the words this court in this context. And number two, it means this bench. The three of you sitting here as a bench, you are now this court in this matter. You have unfettered jurisdiction to check the constitutionality of the process at whatever stage. At paragraph 87, you reiterated that you are exercising judicial restraint in order to accord constitutional entities the latitude to deal with their mandates. But then you said, we however clarify that courts can and ought to readily intervene in ongoing processes before any entity in the clearest of cases where there is evidence of flagrant and gross violation of human rights and fundamental freedoms. I began by telling you, the most flagrant is the happening of 18th of October, 2024. The most undebatable. The National Assembly received a nomination of Honorable Kithure Kindiki from the President. The National Assembly had in its face Article 118 of the Constitution. In its face. I'm sure some members are sitting here of the National Assembly. They had in their face Article 118 of the Constitution. That article continued to pronounce itself because Article 259 says the law is always speaking. So this article was consistently speaking to the National Assembly. Consistently speaking that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The law continuously spoke. The Speaker called the House Business Committee. They met. Article 118 was speaking to that committee that you shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. That committee turned a blind ear to this speech by the Constitution. They sat in plenary. Article 118 1B was speaking that you will facilitate public participation and involvement in the legislative and other business of Parliament and its committees. The plenary turned a deaf ear. 2, this dictate. The most blatant. I want to ask how we cannot stop the confirmation, the assumption of office of Honorable Kindiki on this argument only. until we argue this matter fully and settle it at the hearing of the main petition. I want to see. I'm a career learner. If you convince me, I can tell my clients they have convinced me. But I'm trying to imagine the kind of philosophy you will require to convince me. The 50 million Kenyans out there know. None of them was ever called upon to make any view, any thought on the suitability or otherwise of Honorable Kithure Kindiki to be the Deputy President of Kenya. They know. Then, at paragraph 90 of that ruling, you observed, in other words, this court is still able to grant a remedy even after the process in Parliament is concluded. You again asserted your jurisdiction. I want to conclude this aspect of my submissions, my lords, my ladies, by pointing out that it's a high time that we laughed out of this court anyone who questions the jurisdiction of this court in this matter in view of all these prior rulings in the files before you. Allow me to then briefly address you on the other aspects of issuance of conservatory orders. Again, I will not go further than your own earlier rulings. In your ruling of 16th October 2024, at paragraphs 62 to 71, you pronounced yourselves on the principles that govern grant of conservatory orders. We agree with each of those principles that you set out in that ruling without any modification. We agree with each of the principles that you set out in paragraphs 61, sorry, my apologies, 62 all the way to 71. I will address myself to only one, Amunya versus Dixon Mwenda Githinji and two others. If I'm not mistaken, this must have been the matter that was argued by my colleague, Dr. Tiankolu, sometimes back, so he would know it very well. It was among the first cases to deal with this matter. It's actually the first one in the Supreme Court of Kenya. You see, we celebrate Dr. Muthoni Tiankolu for contributing to this kind of jurisprudence. He observed, and I quote, that conservatory orders, consequently, should be granted on the inherent merits of a case, bearing in mind the public interest, caution of values, and the proportionate magnitudes and priority levels attributable to the relevant causes. I want to address myself to the inherent merit of this case and just on one aspect of public interest. In fact, let me just begin by putting aside the issue of public interest, by asserting as a principle, my lords, that I desire that you hold that the greatest public interest is upholding our Constitution. There can be no superior public interest attributable to politics or other considerations that would outweigh upholding our Constitution. In fact, that is my understanding of Articles 2 and Article 3 of the Constitution. Articles 2 and 3 of our Constitution provide that the greatest public interest is in upholding our Constitution. I can see my learned colleagues jittery. I don't know whether they want to raise an objection. Okay, thank you.
Not me. I would never raise an objection.
So that, my lords, when a petitioner raises a matter like the clearest violation I have raised on what transpired on 18th, there can be no greater public interest than giving that matter a chance to be ventilated fully. I can't imagine of any. But having said that, let me now deal with how this petition meets the inherent merits test.
Just a minute. We had earlier on given a time allocation, which Mr. Kibe disagreed with and asked for 2 hours. We will give you that 2 hours and not beyond. You have done 1 hour.
Okay, let me now take 15 minutes to summarize the rest of the argument. Then we see how to wind up that. So let me address the issue of inherent merit, because that's my last argument. Then I can see what my learned colleague, Mr. Masharia, can mop up. We had gotten another indication, my lord, that we have the whole day. That's the last direction you gave before this one. So that's why your words, my lord. I'm sure the transcript will come out with those words.
That is, we speak as Africans.
Let me do the best I can in view of the new direction, because that has made me now to change my approach, which can...
Certainly, Mr. Ongoya, you didn't expect that we have the whole day. We had given directions on time,
Yes.
And on your own authority of Mr. Kibe, he said you would want 2 hours. And we have agreed to that. So let's stick to the petitioner's side having 2 hours.
Let me give it my best. We'll deal with the eventualities. Allow me then just to refer you to a few things. On your ruling of 16th October 2024, at paragraph 78, you observed, and I quote, "In sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law has been contravened or is threatened with contravention." Then you at paragraph 79, you observe, applying the above in this matter, petition 522 that is before you now, without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration. You made a finding that the case has inherent merit. You could see it without much ado. At paragraph 93 of that ruling of 16th of October, you observed that we have no doubt in our mind, your mind was clear, my lords, that this matter raises issues of immense public interest. A matter that raises issues of immense public interest, we argue, is a matter that is infused with inherent merit. When you consider the ruling of your brother, Justice Chacha Mwita, at page 9, paragraph 3, in petition number 550, which is now before you, the judge observes, and I quote, "There is further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency to demonstrate this fact. According to the public participation results for that constituency, the total number of people who participated is given as 43. Those who are in support are given as 70. Out of 43 participants in a public participation event to remove Mr. Gachagua, out of 43, 70 approved." My lord, that's the case before you. This is how we have treated His Excellency regarding Gachagua, my client. Those who did not support were 3. They also got those who did not support. Having gotten 70 out of 43, there has some residue of 3 not to support. The percentage of those who support was 162.79%. we used to distinguish law and mathematics by saying that mathematics gives us instruments of mathematical precision. I don't know what the National Assembly will do with this mathematics, but this is curious mathematics. The judge then observes, it is implausible that an attendance of 43 people will produce 70 people in support and 3 in opposition. I submit that there was no remedial measure to this blatant failure by the Senate. There was no remedial measure. This poison has worked with this dispute throughout the process up to the time we come here. I'm making out a case that this case has inherent merit by these findings. At page 11, the judge referred this matter to the Chief Justice to empanel a bench on finding that the issues raised in this petition were immense. Again, that speaks to the inherent merit. When you look at the ruling of Justice L.N. Mugambi of 11th October 2024, all the way from paragraph 38 to paragraph 42, the judge highlights the matters of grave significance that this petition raises as a precondition to referring this matter to the Chief Justice. I submit that this speaks to the inherent merit of this case. And finally, at least for my part, when you look at the order from Kerogoya in petition number E15 of 2024, which is before you, at order number 3, the judge observed that the matters raised in the petition being of great national importance and urgency. He then referred the file to the Chief Justice. And I have 2 observations to make here. The finding that the matter was of great national importance and urgency speaks to the inherent merit of this case. If you look at order number 5 of the order of your brother Justice Mwongo, he gave the conservatory order because of the finding in paragraph 3, in order 3. He says, in light of the nature of the matters raised as noted in order 3, a conservatory order be issued. I want to submit to the nature of those matters has never changed. For you to vacate this order, you must convince yourselves, convince us, and convince the entire Republic of Kenya that the nature of these matters has changed. The matter has remained as it was on 18th of October 2024, which was the basis for the grant of conservatory orders. I therefore submit as follows: that because this bench, Justice Mugambi, Justice Mwita, and Justice Mwongo have, in the various rulings above, already found that this matter has inherent merit, it is not open to the respondents in their application for setting aside to invite this very court to revisit that matter and reach a contrary finding in the face of the principle of res judicata that you considered and applied on 16th of this month. I also submit that because the 4 benches I have alluded to have consistently found that this court has jurisdiction, it is not open to the respondents to argue that this court has no jurisdiction and invite this court to enter a contrary view without violating the principle of res judicata that you used against the petitioners on 16th of October. I trust that my learned colleague, Mr. Macharia, has taken note of the time, and therefore he is able to compress arguments so that we pave way to the other petitioners. I urge that you grant the conservatory orders in petition number 565 of 2024 and in petition number 15 of 2024 at Kerogoya to preserve the subject matter and to give these parties a chance to ventilate themselves on the merits in the main petition. Over to Mr. Macharia.
If it pleases your ladyship and my lord, I will speak to three issues. The first of those issues is an issue raised most robustly by my colleague, I believe it's Dr. Fiankolu, and it is the question of political question. The second issue, my lords and your ladyship, will be the question of fair hearing. And the third one will be jurisdiction in the context of Article 40. Let me begin with the last one. In response to what the petitioners will tell you this morning, you will be treated to the most astonishing claim in our 10 years of the Constitution 2010. You will be told that the National Assembly and the Senate and the Executive have a dictatorship, have an autocracy on political questions, that those questions cannot be questioned by this court. That is the textbook definition of dictatorship and autocracy. The Constitution of Kenya, beginning at Article 1 and going to Article 10 and on to the end, is replete with the word accountability. Kenya is not a presidential democracy. Kenya is not a legislative democracy. Kenya is a constitutional democracy. When we gave ourselves this constitution in 2010, we introduced into it a concept known as limited government. And what that concept means is that those who are accorded powers under the constitution can only exercise those powers within the four corners of the power granted to them. That is number one. And that number two, on account of Articles 1, Article 2, and 3, all those decisions are amenable to judicial review for purposes of confirming compliance with the Constitution. My good friend, Mr. Dr. Fiankolu and his colleagues have in their submission cited to you a case which they have extracted from the Sonko, allow me to call it that, the Sonko Supreme Court decision. They tell you that on the basis of a decision called Nixon versus the United States, you have no jurisdiction on account of the political question doctrine. But what they've done actually is that they cut out the passages and left out the decision that the court actually made. This is what you will find at paragraph 113 of the Supreme Court decision. And so far, it's the only, I think, full decision by the Supreme Court on the question of impeachments. Full decision after an impeachment. This is what they say. In that sense, and and this is now a continuation from where the respondents here have cited in their submissions. In that sense, and in the exercise of these wide political powers, both the County Assembly and the Senate cannot act outside the confines of the Constitution. So that's the first point. The Senate and the National Assembly, even while acting politically, cannot act outside the confines of the Constitution and the law. That's number one. And they then say, and this is where you draw your jurisdiction from, for to do so would invariably invite the court's intervention, which is what we're asking you to do here today. They then cite the case of Nixon, which itself stated that there must be judicial review when state organs or state bodies misbehave. But this is what the court says. Courts are thus permitted to intervene where matters of constitutional violations arise. And that's not the only one, of course. We've cited before you other cases, including the Wambora decisions, where the court, both the Court of Appeal, went to great lengths to explain where you draw your jurisdiction from. So I believe the Supreme Court decision in the Sonko case should put to rest the question as to whether you have jurisdiction even on political questions. The respondents then make another submission. This is that this court lacks jurisdiction because jurisdiction to interrogate the presidency and its appointments or elections lies exclusively within the Supreme Court of Kenya. They don't say so explicitly, but they say so by way of example. And they tell you that under Article 164, I believe it is, Article 163, Sub-Article 3A, the exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the president arising under Article 140. It's important to linger on every of those words. The exclusive jurisdiction is limited to elections, number one, arising under Article 140. And there's a reason it's worded this way, and here's the reason. Now, not every election is a presidential election. Now, under the definitions set out under the Elections Act, the Elections Act is itself a statute promulgated by Parliament under the provisions of Article 82 of the Constitution of Kenya. It recognizes only 3 types of presidential elections. The first is Article 136. It is that election that leads and that has the qualifications and the mechanism for it under Article 138 that then leads to a petition in the Supreme Court of Kenya under Article 140. There is then another election under Article 139, Sub-Article 1B, and you will find this in the definitions of the Elections Act. And the third presidential election understood is Article 146, Sub-Article 2B. A replacement of a deputy president under Article 149 is not an election. And I must confess that Article 149 was perhaps not worded very elegantly, because what Article 149 does is that Article 149 almost seems to have ended prematurely, because it says within 14 days after a vacancy in the office of the deputy president arises, the president shall nominate a person to fill the vacancy. So it's a nomination. The word used there first is nominate. A person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. It doesn't say anything after that. But one of the things I found when I examined another statute with similar provisions, this is Section 32D of the County Governments Act. Section 32D of the County Governments Act is actually a lot broader. It explains how that vote will be conducted, the time periods for it, the threshold for that vote. It's a lot more elaborate. But one of the things it makes clear is that the vote akin to Article 149 is an approval. It's not an election. It's an approval. And if one were to examine the Constitution further, everywhere the word election is used, and just by way of a few examples under the Constitution, Article 86, Article 87, Article 83, all of those articles, including the powers and functions of the IEBC, which my learned friend Mr. Ndegwa will be speaking to later, all of those make it clear that the election contemplated is a contested election with voters under Article 1. 14 million Kenyans. That is what the Constitution understands as an election. That then invites the jurisdiction of the Supreme Court of Kenya under Article 140. So it cannot be that the respondents get to make 2 opposing arguments. They argue that because this is their argument, this is an election, so you can only go to the Supreme Court of Kenya. But they then argue this is not an election that requires the IEBC. That's one of the things they've argued. Because an election requires the IEBC, as properly understood. So even that argument that the Supreme Court of Kenya is the only one that has the repository of jurisdiction to determine this matter does not find any basis, does not find any grounding in the Constitution of Kenya. You can also look at Article 106(2)(a) for what they discuss when they talk about an election. So Article 149(1) does not envisage any contest. The president nominates one name. And while I'm here, let me deal with an elephant that my learned colleagues will be throwing at you. It's actually more of a monster. In response to what we are telling you, they will tell you there's a public crisis of monumental proportions not seen since the late Daniel Arap Moi told us that he will appoint a vice president if it increases the sufurias of ugali in our houses. We'll be told this is the worst thing that has ever happened. There's a vacancy. Answer number one, Article 148 does not 148, sorry, I believe I'm talking about the sequencing where the Speaker of the National Assembly is the third in command, so to speak, when there's a vacancy. I have been waiting for my good friend, Mr. Milimani, who represents the Speaker, to shoot up to his feet and protest loudly that his client is not a vacuum. Because the Constitution says, when, I think it is, this is Article 146, Sub-Article 2(b). If the office of Deputy President is vacant, or the Deputy President is unable to assume the office of President, the Speaker of the National Assembly shall act as President, and an election to the office of the President shall be held within 60 days after the vacancy arose in the office of the President. Two things to note there. In that article, the framers of the Constitution contemplated a vacuum in both the presidency and the deputy presidency. And it is at this point where my good friend Mr. Milimo says his client, Anatosha. Maybe you'll say it. I am almost certain in the event that my good friend Mr. Kamoto described here a few days ago, when he said the president might go to where people don't come back from, that we will all say we turn Atosha. He did. The record says so. Yeah, but we understood him. He was not wishing ill. So that's the first thing. The second thing, my lord, is that they contemplated we can operate for 60 days, 2 months, without either a president or a deputy president. The world will not collapse. Kenyans made adequate arrangements for the caretaker, while those two are not with us. And there seems to be something magical about these 60 days that Kenyans clearly had. Because under Article 149(1), when the deputy president is impeached or there is incapacity, the president has 14 days to nominate a candidate to the National Assembly. That is number one. And because it is not obvious, or it is not a matter of course, that the National Assembly will approve that candidate, it must be contemplated that the National Assembly can refuse to vote for that candidate. So those 14 days can be repeated, which is what the Constitution says. If Parliament rejects the first candidate, the process is repeated again. And the Constitution seems to contemplate, can be repeated almost indefinitely until the President comes up with a name that is acceptable. So that is number one. And there's no crisis. The world will not end as Parliament rejects those candidates. So that's number one. But the President having nominated a candidate, the National Assembly itself has then another 60 days. So we can again operate as a country for 60 days without a deputy president. And so I return to what the Supreme Court said in the Sonko case we must do, and has not been done, has not been afforded to our client, the Deputy President. This is what the court says. This is the Supreme Court again at Article 140. Question whether due process was followed in the removal of the appellant. The audi alteram partem rule requires that those who are like ill. I have subsequently read in the newspapers he had a broken heart for good reason. So he is taken ill, and the Senate then takes a vote. And this was important because the Senate had 2 days left, even in their own self-prescribed time limits. They voted, and this was not an electronic vote. They voted on acclamation to reject a motion to extend time for the Deputy President to appear
My
in
Lord,
court.
if I may, I am compelled to interrupt. My Lord, learned counsel is misleading the court. When on affidavit, it is clear that the Senate votes electronically. Senate does not vote by acclamation. Itself too, on the question of acclamation, we can't just sit back and watch Mr. Macharia mislead the court.
I was personally there. Senior Counsel Mwite was there. The entire team, most of them were there. On the question of extension of time, it was by acclamation. All the ayes and all the noes, that's what it was.
And the senator was loud.
Yes. And I would ask him to please wait. He'll be a bit more bothered when I finish with my submission, so he can be heard. To call witnesses, to be represented by counsel, to be availed adequate time and facilities to prepare, and if the accusations are proved, to be given the reasons. This is important. The Supreme Court says you must be given reasons for your decision. There are no reasons. They voted on grounds submitted to them by the National Assembly. They did not give reasons for that decision. Of course, beyond there, they are also entitled to challenge the decision. Again, to challenge the decision. If against them, before a higher court or tribunal. Every person to fair administrative action. The manner of actualization of those rights have been enacted in the Fair Administrative Actions Act. Now, when this Honorable Court retires to do its ruling, I would invite you, with tremendous respect, to pay attention to sections 4 and 5 of the Fair Administrative Action Act. They're important in more regards than one. Senior Counsel Paul Mwite has alluded to the question of public participation, and so will some of my colleagues who will come after me. When the National Assembly conducted what it called public participation, it did not avail to the public the response by the Deputy President. What they did is prepare a charge sheet, a copy of which we will find as Annexure 8 of our affidavit in support of the petition, which for ease of reference is at page 498. That charge sheet asks 3 questions. It first sets out the 10 grounds that the motion promoter had set out, and then asks people, do you agree that the Deputy President should be impeached on these grounds? Do you not agree? And then there was a third one, other. That was it. They were not told what his response was, nor was he given an opportunity prior to this process. Because the only way, and you'll find that this is one of the things the Supreme Court says under the Article 47 in Fair Administrative Action Act, the participants in this public participation must know both sides of the story to make an informed decision as the people who voted in this manner. The court then goes on at paragraph 116. In the process of removal of a county governor, and for this case, the Deputy President, the right to fair administrative action under Article 47 and the right to fair hearing under Article 50 of the Constitution all accrue, and I'm paraphrasing here, to the Deputy President before a decision to remove him or her from office is reached, An unfair removal is one which goes against the principles of natural justice, just like I've demonstrated, which implies that no adequate notice was given, that there was bias, and where the hearing was not fair. In our amended petition, which you will see in the fullness of time, we have given particulars of how each and every of these issues was violated. The Senate and the National Assembly, first and foremost, constricted the time allowed by the Constitution for themselves. They cut their own time short. And so no one had sufficient time to do anything. We have said they introduced new evidence as the trial was going. There was panel beating as the matter was going on. And as I've said, there was a lack of fair hearing. Though, this is Supreme Court, though a political process, impeachment is sanctioned by the Constitution and the law and is not a platform to settle political scores. This speaks to what Senior Counsel Paul Muita said a few minutes ago. It's not an issue of ticking boxes, going into a room and saying 300 of us have said you're a bad man, you must go. You're a bad woman, you must go. You must comply with each and every of the provisions of the Constitution. Bearing in mind that the removal architecture in the Constitution, the law, and the standing orders are designed to achieve accountability, political governance, and personal responsibility, and are not aimed necessarily to find criminal responsibility. On the question of natural justice, this is what, this was a decision by, I believe, your brother, Justice Odunga. It's in our list. This is miscellaneous civil application number. Rule of natural justice that no one should be condemned unheard. Natural justice is not a creature of humankind. They're asking you to take away a creature. And let me, in the Latin phrase, audi alteram partem, literally translates into hear the parties in turn, and has been appropriately paraphrased as do not condemn anyone unheard. That is what the Senate did to the Deputy President. You cannot allow their resolution to stand. There is a decision, I will not read this for you. I believe this is miscellaneous application number 266 of 2017 at paragraph 109, the decision of the Supreme Court of Kenya in Speaker of the National Assembly versus Attorney General and 3 others, where the court again restated, the Supreme Court, your jurisdiction in these circumstances. And then to the Senate proceedings I've just read out for you. In the Wambora, in the Martin Wambora case, this is what, this is the case, this is, it's cited in the Mike Sonko Mbuvi case, what the court said about what my good friend Professor Ojenda was to direct the legislature on how to perform its functions. We are of the considered view that impeachment of a governor is a serious undertaking, just like a deputy president, as the end result can lead to the removal of a popularly elected governor. The deputy president before you and the president who ran for election in 2022 were elected by a vote of slightly over 7 million people in this country, out of 14 million people who participated. It's a very serious matter. For this reason, we recommend not to avail itself of this constitutional mechanism. The committee gives the perception that each member is actually engaged in the process as opposed to the plenary. The trial of the deputy president was held entirely in plenary. And a lot of things, when you look at the Hansard, for example, there was a lot of issues raised about a will, about a succession matter that has nothing to do with the Constitution of Kenya. From Kangema, the late John Joseph Kamotho used to call Kura ya Makelele. Now, under the grounds, missions which are dated 28th of October, 2024, we have cited before you a case by the Court of Appeal, Attorney General versus Matindi and 55 others, where the court explains the following. A successful appeal is not reduced to a mere Pyrrhic victory or paper judgment. Whether or not a matter will be rendered nugatory is determined on a case-by-case basis, depending on the peculiar circumstances of the case. But ordinarily, the court will grant relief if what is apprehended cannot be undone once it happens, or cannot be undone without undue hardship or expense, or cannot be adequately compensated by an award of damages. The court takes into account the respective hardship that grant or refusal of relief is likely to rot on the parties. I want you to take my colleagues' submissions where they say you cannot undo. Once a new candidate for deputy president is nominated and sworn in, they say the court has no jurisdiction to undo that appointment. This is what they're telling you. You cannot undo a deputy presidential nominee who has been sworn in and has taken office. This is what they're telling you. At any length, they tell you, this is a political question, don't even look at it. That's why they began. Don't even look at this. The president knew what he was doing, take him at his word and at his actions. So that's one side of the balance, of the scale. On the other event, his petition were to fail. All he does is go back home and we swear in the new one once the petition is dismissed. But conversely, if you swear in a new deputy president, you kick in motion a whole series of events, including a president, a deputy president, who is now exercising constitutional mandate, who is chairing cabinet committees, that may ultimately be found to have acted outside the Constitution of Kenya. The balance lies in granting conservatory orders so that we can do this in a civil manner. What former Supreme Court Judge of the Supreme Court of Kenya, Justice Ojwang, used to call a pacific resolution of the dispute. As I said, the Constitution has given ample time for all of us to interrogate these questions. 60 days is the magic figure the Constitution gave us. Let's not be in a rush to undo the timelines given to us by the Constitution. And finally, the decision of, I believe, Gachagua'S Munya, the question of the public funds that are expended, swearing in a new deputy president, getting him a whole fleet of cars and workers, and the trappings of power, and as is the custom, perhaps even doing the road to his village home, all these sort of things. So let's hold our hands until we can determine whether the process that led us to this day was done constitutionally. That is the Peter Gachagua'S Munya decision. My lords and your ladyship, the decision you make in this matter will echo in eternity. It will be a turning point as to whether we continue being a constitutional democracy or a dictatorship and an autocracy. I beseech you, do not let us go down the path of autocracy and dictatorship. Thank you for the privilege of your attention and your time. Unless you have any questions for me, I'll hand over to one of my colleagues. Thank you.
Thank you.
My Lord, my name is My Lord, my name is Kibe Mungai. The team leader is Paul Muite, Senior Counsel, assigned this application, the one from Kerogoya, to me, Professor Ogada, and Mr. Gachagua'S. As I had already indicated to the court, and with the benefit of the submissions from my learned colleagues, we shall try to do our business within an hour. So I'll start first, followed by Mr. Ogada, and then Mr. Gachagua'S, for purposes of presentation. Honorable David Munyi Mavenge, on the same date.